सब्सक्राइब कीजिए हमारे YouTube चैनल शॉर्टहैंड डिक्टेशन लीगल मैटर्स को और दबाइए इस बेल को ताकि आपको मिल सके हमारा वीडियो सबसे पहले और यह बिल्कुल फ्री है।
Ready, start. This writ petition has been filed for quashing the entire proceeding initiated under section 15 of the Uttar Pradesh Kshetra Panchayat and Jila Panchayat Adhiniyam 1961, including the order and notice dated 26/2018 issued by the District Magistrate / Collector Kushinagar. The petitioner is the Block Pramukh of Block Dudhai. From the perusal of record, it appears that a written notice carrying the signatures of 81 elected members of Kshetra Panchayat Dudhai has been delivered to the District Magistrate / Collector Kushinagar for convening a meeting of the concerned Kshetra Panchayat for the consideration of no confidence motion against the elected Pramukh. The main contention of the learned counsel for the petitioner is that out of the 81 members of Kshetra Panchayat Dudhai, signatures of 13 members are forged / fabricated, regarding which they have filed their affidavits before the collector Kushinagar and the collector Kushinagar without making any inquiry with regard to genuineness or veracity of the signatures endorsed by the said 13 members of Kshetra Panchayat Dudhai, proceeded to fix the date for convening a meeting of the Kshetra Panchayat for the consideration of no confidence motion against the Block Pramukh. Heard Sri Ramesh Chandra Singh, learned counsel for the petitioner. Sri Shashinandan, senior advocate, assisted by Sri Mahendra Singh, learned counsel for the respondent, numbers 4 and 5. Learned additional chief standing counsel appearing on behalf of the respondent, numbers 1, 2, 3, and perused the record. At the very outset, learned counsel for the respondent, numbers 4 and 5, has placed the decision of the full bench of this court in the case of Srimati Sheila Devi and others versus State of UP and others 2015 within bracket 2 ADJ 325 within bracket FB, wherein paragraph 15 it has been held as follows. In our view, both the decisions of the majority as well as the minority essentially follow the same line and the area of dissent is rather narrow. Both the judgments of the majority as well as the minority postulate that the collector ought not to make a detailed inquiry where serious allegations of fraud, coercion, and duress are required to be resolved, particularly having regard to the fact that a meeting had to be convened as soon as possible. The area of divergence is only this, that whereas the majority left it open to the collector to determine whether and if so what inquiry should be held, the view of the dissenting judge was that the collector should hold an inquiry so long as a detailed inquiry into serious questions of coercion or fraud was not involved. In either view of the matter, and since we are bound by the judgment of the full bench, the law on the subject is thus clear. The collector, in the course of exercising the power which is conferred upon him, ought not to inquire into seriously disputed questions of fact involving issues of fraud, coercion, and duress. Moreover, the collector must have the discretion in each case of determining on the basis of a summary proceeding whether the essential requirements of a valid notice of an intention to move a motion of no confidence have been fulfilled, where in the course of the summary inquiry it appears to the collector that the written notice does not comply with the requirements of law, the collector would be within his power in determining as to whether all the required conditions have been fulfilled as enunciated in subsection 2 of section 15, where the collector in a given case has transgressed his power is separate issue on which judicial review under Article 226 of the Constitution would be available. Stop. Difficult phrases: genuineness, veracity, endorse, convene, postulate, dissent, coercion, duress, discretion, transgress.